Thank you, Mr. Chairman. I just want to note for the record regarding the emoluments lawsuit, Attorney General Sessions, you said that it had no merit, but the clause basically says the president, without consent of the Congress, cannot accept any present from a foreign state. And if the argument of no merit is that the money doesn't go directly to him, but to a company or any of his those kinds of entities, then it is up to the court to decide if the emoluments clause can be so easily evaded.
Fair enough, and I would just say
that was just a statement.
You're right. The court will decide, and
yes.
We've taken a position on that question.
So in response to a question from Senator Feinstein, you provided an explanation as to why Director Comey was fired. The thing is, though, that explanation was directly contradicted by the president in public, where he said that he fired Director Comey because of the Russia thing, and that he also said that he was going to fire Director Comey anyway, regardless of any memo that you presented. So are you now contradicting the president's explanation?
All I said was, Senator, was that the Deputy Attorney General and I were asked to give our opinion, and we did so, yes. And the president made the decision, and he's talked about it to some degree publicly. Actually, I don't know exactly what he said.
You were asked to give an explanation of why Director Comey was fired, and you said it was because of the letter that was sent to the president, and he directly contradicted that. So I think that stands for itself.
If I did, let me correct myself. All I intended to say was that we were asked to give an opinion, and I gave it. The president makes a decision in the end.
Yes, I realize that, but I believe that you were providing an explanation as to why the president fired him. So let's move on. When you were here for your confirmation hearing, I specifically asked you some questions about consent decrees that the Department of Justice had entered into, and at that time there were 20 of them, I believe, and in 1994, Congress enacted a statute that authorized lawsuits specifically to target a pattern or practice of unconstitutional behavior in law enforcement agencies. During your confirmation hearing, you made it pretty plain that you were not a big fan of these kinds of consent decrees, calling them, quote, a dangerous exercise of raw power. And although I asked you at that time whether you were going to amend any of these existing consent decrees that have been negotiated, agreed to, and approved by the courts, my recollection is that you weren't sure, but in fact, you are reviewing all of these consent decrees. Can you tell me why you're reviewing them and whether you plan to amend any of these existing decrees and whether you intend to make public any of the findings of your review of the existing consent decrees?
Well, consent decrees are never to be permanent. The federal government nor the court should be permanently in charge of running police departments and sheriff's departments in any city. There's a situation in one state where a sheriff was sued about a jail that was improperly being run or in improper jail. A new jail has been built, and perhaps we should see about removing that from the jurisdiction of the court, since he's apparently met the challenges that he was given.
So you, excuse me, I am running out of time.
Okay.
I hate to be rude, but there you have it.
Okay, go ahead, please.
So you have some concerns about the time frames of consent decrees, because my understanding of consent decrees is that they do not go on in perpetuity. What they want to see is that some improvements occurring. So why don't we get to the question of whether you intend to make public the findings of your review of the consent decrees that are in existence?
I don't know that we have any systematic plan to review consent decrees with the idea of terminating them. But we should begin to terminate decrees that are ready to be terminated. Secondly, I don't have the unilateral power to do so. The court has already taken jurisdiction, and if the parties don't agree, even if the Attorney General recommends a termination, the judge would have to find that is appropriate.
Okay, granted. So are you going to make your recommendations public after your review?
Well, if we ask for a a termination, it would be public. It would have to be filed in court.
I think that you are,
So we would normally.
I asked a very simple question as to whether or not you would enable the public to understand the basis of your review. And of course, by the time it has to be terminated, you have to go to the court. I understand that. So, okay, you're just not responding to that question. Let me get to your religious liberty memorandum. On October 6th, you issued new guidance on religious liberty, broadly directing federal agencies and attorneys to observe 20 principles of religious liberty. And you also issued a memo on how the Department of Justice should implement these principles, and you said they should be incorporated into litigation strategy and arguments, operations, grant applications, pending cases, and opinions for other agencies. And I'm wondering, did you issue principles relating to, for example, what the DOJ should do with regard to civil rights issues or individual liberties issues or voting rights or on Second Amendment cases?
We've not issued such a statement of principles on other issues.
But on religious beliefs, you did. And in fact, let me point to one of them. Section 8 of your memo says that government cannot selectively impose regulatory burdens on some denominations but not others, et cetera, et cetera. And frankly, Mr. Attorney General, this provision leads me to question whether, for example, this section raises questions such as whether the government can grant an exemption to the Affordable Care Act's essential benefits requirements to a business owner who claims to adhere to a religious faith that only practices faith healing and believes that any other sort of medical intervention is morally wrong, or raises the question such as whether a business owner who has a demonstratively false religious belief that all vaccines contain fetal stem cell tissue or cause autism and believes that providing coverage of vaccinations to his employees is a substantial burden on his free exercise rights. So, Mr. Attorney General, I would say that these 20 principles, religious principles, I only cited to one that raises the kind of concerns that I have. Let me go on to another question. LGBTQ rights. In a case argued earlier this year before the Second Circuit, the Zarda case, your department submitted a brief and argued that Title VII of the Civil Rights Act of 1964 does not prohibit discrimination on the basis of sexual orientation. And I believe that you expanded that in a directive to include sexual identity. And this is inconsistent with the 2015 EEOC guidance and also with a recent en banc decision from the Seventh Circuit Court of Appeals. Does it violate federal law to fire an employee because they are gay?
We carefully reviewed the law on that. My staff has. Since the 1964 Civil Rights Act, of which Title VII is a part, it has been interpreted that way. All circuit courts of appeals had interpreted that way, except this year there was a reversal. I believe the Seventh Circuit you indicated. So the position we have taken in the litigation is consistent with the President Obama's Department of Justice, all but one of the courts of appeals, and it's been that way for quite a long time. So we took the lawful position. It's distinctly the minority position to hold otherwise.
I just need to have that clarified, Mr.
Senator Feinstein, now for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, the end is nearing. In April, the district judge in Hawaii, Judge Derek Watson, ruled in a case relating to the president's executive order travel ban. And you made a remark at that time that, to put it nicely, was ignorant. Not that you were ignorant, but the remark was ignorant. And you said, "I really am amazed that a judge sitting on an island in the Pacific can issue an order that stops the President of the United States from what appears to be clearly his statutory and constitutional power." Of course, that island in the Pacific happens to be Oahu, where Judge Watson sits.
A beautiful island indeed.
Yes, thank you for that.
The birthplace of my wonderful granddaughter.
When a public official like you makes a statement like that, it tends to legitimize the views of people who think that the great ethnic and racial diversity in my state makes us somehow less American. So do you still stand by your statement?
Well, I had no idea that it would be interpreted that way. There are 600 federal district judges in America, and the president issues what I believe is a lawful order that I believe will be upheld by the Supreme Court.
And every
And
single
one of those judges, this one happened to be on an island in the Pacific.
Yes, and so you would acknowledge
stop the entire process. And I think these judges need to be careful that they're not just setting policy and
Well,
using their power.
Let me get to one more, then
Block
clarification.
the president's ability to protect America.
Excuse
Just let me finish.
I know, we heard you, I heard you when you gave your explanation, but clearly that all district court judges can issue injunctions, can issue rulings that impacts the entire state, entire country. Because that happened in the Texas situation where this Texas district judge prevented the implementation of President Obama's DACA expansion and DAPA. So you're not saying that district judges do not have that authority?
Under the current law, they do. It's been going on for quite a number of years.
Yes.
Picked up some speed. It's subject to criticism, and judges need to be careful before they do that.
Let's say that they are. Regarding the U.S. attorneys, who was involved in the decisions to dismiss all of the U.S. attorneys without any warning, and why was it done when it was done?
We had gone for a number of months. About half of the United States attorneys in the country had already resigned. It's traditional that they're replaced by the next administration, and President, I believe President Clinton did the same, issued a single order. There's precedent for it to complete the process of changeover.
So it was totally President Trump who made that decision. You were not involved in that decision?
I believe the responsibility is the president's.
You were not involved in that decision to fire them all?
Actually, I think the attorney. I can't believe I can't remember that. But it's an important issue. The president appoints United States attorneys, and it was appropriate, I thought, at that time to make the change.
So you were involved?
Yes, I was involved.
I have a question about DACA. When the young people signed up for DACA, they were relying on I suppose what they were told or given information that the information they provided would not be used to target them for deportation. And now there are at least 3 pending lawsuits, 2 I believe in New York and 1 in California. And the basis of the lawsuit is that there are due process concerns about the president's action to end DACA as a bait and switch, due process concerns. Did you consider the bait and switch problem in issuing your letter of opinion on the legality of DACA?
I believe it was known and considered. Obviously, it's the Department of Homeland Security that decides how to administer and gather evidence and what cases to make priorities
Except
on.
that you were the one who said that DACA is unconstitutional and illegal. That was your opinion that you issued.
Right.
So did you consider any due process considerations, bait and switch considerations when you issued that letter of opinion that it was unconstitutional?
I don't believe there was any explicit discussion of that, anything in any documents from the Department of Justice, but it's a valid issue that needs to be discussed and considered.
It will be in
You're right to raise it.
cases.
And I don't think Homeland Security has any policy to do as you suggest.
Well, there are a large number of DACA recipients who have renewed their DACA status for 2 years, and they have different expiration times for when their DACA status ends. What happens to the recipients of the DACA if DACA ends in 5 months, for example, or if these 3 pending cases determines that DACA is in fact unconstitutional? What happens to these DACA recipients who are whose DACA status have not expired, but if the court says that they are this is based on an unconstitutional law? What happens to these people?
Senator Sessions, before you answer that, you'll be done when you get 2 more questions from Senator Blumenthal. He wanted a 3rd round, and that'll be the last one. Then we're going to go vote anyway. So go ahead and answer Senator Hirono, and then Senator Blumenthal will ask you his questions.
All right, so you were asking?
If DACA ends in 5 months and the Congress has not acted and all
Yes,
these DACA recipients are still DACA recipients, or if a court, because there are 3 pending court cases, if the courts decide that this is unconstitutional, what happens to all these people?
The answer to that is in your hands. Congress has the ability to deal with this problem in any number of ways. The president is indicated he's willing to support reform and try to work to fix this problem and help these young people that justify help if Congress so decides. And I think we need to get on with it. It's not going to work with just simply an amnesty without any improvement in the loopholes and problems and we've got in immigration. But if we work together, something can be done on that.
Well, it all depends on whether DACA is constitutional or not. Thank you, Mr.
We got to let him ask his questions. Go ahead, Senator Blumenthal.